Hey guys, it's Phil Evans with BayAreaLifestyle.com, and today we are here with sweet Georgia Brown of Fidelity National Title. We are so lucky to have her here with us today. She is an incredibly seasoned escrow officer, and she's here to talk with us about all things title and escrow. Okay, Georgia, so we're talking about escrow, and talk to us a little bit about what the escrow process looks like, kind of day to day. What needs to kind of happen that you handle for buyers and sellers?
Sure, I'm happy to do so. When the escrow is first opened, we basically open an open order sheet with the information from the agent. Mm-hmm. And from there, we look for the initial deposit, which is the earnest money deposit. There is a waiting period after that occurs where we are waiting, depending on the close of escrow date, to do anything on the file. If it's a 30-day close, we probably are waiting to get clarification from the listing agent as far as ordering the payoffs for the seller. We're in contact then with the lender, who would like us to prepare an estimated closing statement with the fees on it for title and escrow purposes. Down the road, the lender will contact us again to prepare what they call a CD, or a closing disclosure, with our fees on it and the lender's fees. And that's when we start getting close to proceeding to have loan docs come to us, and then we do the final signing and closing.
That's great. Thanks. Just out of curiosity, because you've been doing this for so long, I know that the average days to close on escrow is oftentimes dependent on the loan, and the lenders get to choose that. But what's the shortest close you've ever done, and what's the longest close you've ever done?
I'll give you that information. Mm-hmm. That's great. Great question.
Just curious, you know.
The shortest probably from opening the escrow is about 10 days. And the reason I say that is because we need to open the escrow, we need to get the prelim, we need to make sure that there's no deeds of trust outstanding from the seller, and then close the escrow. If there were deeds of trust on that simple 10-day close, we would have to order the payoffs and make sure we had them before we were able to close that transaction. The longest escrow I've had is probably about a year and a half.
Wow.
And the reason for that is because there was clouds of title for the seller, vesting issues, where we had to have an attorney go out and help us clear that title.
Okay, great. So what are some of the things that sellers would need to submit to you when they open escrow?
At the beginning of the escrow opening, a seller doesn't need to give us anything just yet. But when we review the prelim, there might be deeds of trust on that property where we are at some point in time going to be requested to order the payoffs. Mm-hmm. These days, we have an order information sheet for the seller, which is really fantastic, and I give those to the agents, the listing agents, and it prepares us for getting the social security number and the information on the loan, so we can have the loan number, social security number, and the mortgage company that they're working with, so we can order the payoff demand. It also has HOA information on there, so if we need to order the HOA, the Homeowners Association, it will give us that contact information, and we take it from there.
Excellent. So what are some of the things that buyers need to submit to you when escrow is opened?
Well, the buyers need to submit their initial deposit, and that's pretty much it. Other than on your contract, if they need to bring in an additional amount of money before the escrow closes. When the escrow closes, usually the buyer brings in their final funds to close, and that's satisfactory. But on some contracts, they are asked to produce a second deposit, and that's certainly up to the agents who have decided that on the contract.
Great. So, we keep talking about title opening or escrow opening and escrow closing. What happens when it closes? Is there any big fanfare? Do people come in and get their keys these days? Like, what does it mean to close escrow?
Well, in order to close escrow, that means that we've recorded, and then the clients are able to get their keys from their agent. And those are exchanged with the agent, listing agent, and the buyer's agent. But that's that's a wonderful day. That means the buyers can move into their property and the sellers can move out of their property. It's a great event. It's payday for the
Payday
agents.
for everybody. Well, yeah, you bet. Those aren't bad days. So you said recorded, but talk to us a little bit more about what recorded and where means.
Well, recording in San Mateo County means in the office of the recorder's office in San Mateo County, which is in Redwood City. And we have people who are down there daily who are recording documents on a daily basis. Recording means something different than when people come in to sign. A lot of times a buyer will come in to sign and say, is it my house yet? And do I own it? No, you don't own it when you're signing escrow papers. You own it when we actually record and get confirmation that we are on record.
Interesting. So that's a very good point. It's
Yes.
not when you sign it, it's when it records officially.
Yes.
That's great. So do people usually, I shouldn't say people, I should say, I guess, does escrow close on time usually, or does it close early? Does it close late more often than not? What should people be prepared for?
They should be prepared, for anything. Anything can happen when we're ready to close. Our challenge is that we've signed the buyer and the papers go back to the lender and the lender has to review those papers. And in turn, the lender will give us what we call a condition sheet. And there might be some missing items from the broker or from escrow that we would need to meet those conditions. But the papers are back to the lender and we're waiting for the lender to fund. Now, the day of close is the day that you have requested us to close. But in many cases, the escrow cannot close on the day because of the lender not funding in time.
I see. Okay.
That's the biggest dilemma that we face.
So what happens if, for example, we're in the middle of escrow and the buyer or seller wants to cancel and get out of escrow? Now, we've already talked about escrow being a neutral third party that holds the earnest money deposit, that holds, other down payment money, things like that, that needs to be distributed. What happens to that money? And can people just decide, I don't want to be in escrow anymore?
Well, they can decide, but it would have to be under mutual cancellation instructions. That's the only way that we can release money to the buyer or the seller. And we depend on our listing agent and our selling agent to give us those terms. A lot of times there might be bills in the escrow where we would actually produce a mutual cancellation instruction where you would tell us, oh no, that one bill needs to be paid out of the buyer's funds. The difficulty is that if you have one party who's not willing to sign the mutual cancellation instructions, and we cannot release any money until those mutual cancellation instructions are met. The difficulty, if that does occur, and we never want to see that happen.
No, that'd be true.
The file would go from us to our legal department, and in turn, legal department would send it off to be what they call interpleaded, which means that the seller and the buyer go to court. You don't want that to ever happen.
So you don't have to decide that.
No.
You just are carrying out
Yes.
mutual instructions.
Yeah, the concern would be is if it gets to that point, your seller and your buyers are going to pay attorney's fees. And I think it's best if the agents, listing and selling agent, can make some restitution as far as how that money's going to be dispersed.
So if you're a buyer and seller, then you can feel confident knowing that once the money that you contributed to the deal is in escrow, it just won't automatically be paid to the other side. It's essentially kind of protected until legally it's
That's
decided who should get that money.
That's correct.
So that's a nice thing.
The concern, though, is that if the seller is demanding money from the buyer in so many terms and not willing to release the money to the buyer after the buyer has decided, that's the difficult part.
Well, Georgia, thanks so much again for being with us today and giving us so much helpful information about title and escrow. Why don't you tell everybody where they can reach out to you at?
I'm at Fidelity National Title in Burlingame at 405 Primrose Road. And my contact number there is 650-348-8261. Ask for Sweet Georgia Brown, and I'm happy to help you.
Sweet Georgia Brown. And I'm Sweet Phil Evans with BayAreaLifestyle.com. You can reach me out at 650-503-3694 or just go to BayArea-Lifestyle.com and you find my email information down there below as well. Thanks so much, guys. Till next time, talk to you soon.